Any mention?
Lordship, I have to mention item number 7, Lordship, from the main list, Lordship. Lordship.
Yes.
Well, I beg to mention item number 4 in the hearing list.
7, Lordship. 7. Item number 7, Lordship.
Let us finish with him first.
Oh, my.
I've already informed Madam Conley, who is appearing for the respondents, Lordship.
She's not here.
No, Lordship. At this moment, she's here.
Yes, madam. Item number 7.
My lord, yes, my friend has already informed me that
When do
they
you want it?
are yet to obtain instruction, my
After
lord.
2 weeks, Lordship.
7. After 2 weeks on the request. Yes.
I beg to mention item number 4. This matter is connected with another matter pending before division bench, where your lordship is one of the there. So this matter may be adjourned. I have taken consent from Mojika.
You are appearing for the union.
I am on behalf of Mr. Chandu. I am praying.
You are the petitioner.
A petitioner.
Petitioner will come that side.
Oh my.
Petitioner.
Sorry, sir.
Yes. Nobody is from the.
I informed the Mojika, Nitish Mojika. He is out of station today. He is in.
Yes.
No objection, Your Lordship.
We'll have it after 3 weeks.
My lord.
Yes.
Obliged.
On the request made by the petitioner on this matter after 3 weeks. We are
Obliged.
not saying that it will be dependent upon the.
No,
disposal
no.
of this.
Simple action.
Yes.
Obliged.
Much obliged, Lordship.
I'd like to mention item 13, Your Lordship. I'm praying if the matter can come after 2 weeks, Your Lordship.
And for the state respondent. It's all right, Your Lordship.
13 after 2 weeks on the request of the petition. Yes.
Obliged, Your Lordship.
Yeah, please, Your Lordship. I beg to mention item number 8, Lordship.
Item number 8.
Yes, Lordship.
Yes. You are making a
I pray
mention
for
on
2
behalf
weeks.
of the appellant.
Yes, Lordship.
No objection, Your Lordship.
When do you want it?
2 weeks, Lordship.
2 weeks on the request of the appellant. Item 8. Yes.
Lordship, similar prayer for item number 6, Lordship. On behalf
Number
of
6.
H. Hazarika, Lordship. He is out of station.
You are petitioner and then respondent, sir.
I'm there, Your Lordship.
No objection. Here. Is there any interim order of any kind?
There is no interim order, Your Lordship. Let it go.
Okay, this was after 2 weeks on the request of the petition. Yes.
Yes, Your Lordship. I beg to mention item number 9.
Yes.
I pray for 2 weeks time, Your Lordship.
Yes, we should.
Lordship, let it go.
Yes. This also.
Obliged, Your Lordship.
May I please, Your Lordship? I beg to mention item number 10 and 11, Your Lordship.
10 and 11.
Yes, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship.
No objection, Lordship. No objection.
In both the matters you are there.
Yes, Boxer.
You are also there.
Yes, Your Lordship. Item number 10.
Okay. Just say 10 and 11. Both will be same order on the request of the petitioner. List after 2 weeks. 2 weeks.
Yes, Your Lordship. A similar prayer for item number 12, Your Lordship.
Item number 12.
Yes, Your Lordship.
Joint prayer, Your Lordship, because Mr. SN also is not available. He's on sanction leave.
So this will go on the joint request.
Yes, Your Lordship.
Item 12 on the joint request. List after.
Your Lordship,
After.
after 2 weeks, Your Lordship.
That's all.
Hello, Your Lordship.
Yes, Your Lordship. Your Lordship, I beg to mention item number 5, Your Lordship.
Yes.
Pray this matter can be taken up after 2 weeks, Your Lordship.
Why?
Personal difficulty, Your Lordship. Today.
We have no objection.
You are for the respondent.
Yes, Your Lordship.
Okay, this is also after 2 weeks on the request.
Highly obliged, Your Lordship.
Supplementary cost list. Item number 1.
Yes.
But this is a quashing petition, my lord, against proceedings, my lord, drawn under the MMDR Act, my lord, Mines and Minerals Development Regulation, my lord. But what had happened is, there's one petitioner, my lord, who's the accused person by name, my lord, Shri Balwan Bhama. Now, my lord, he is a director in the company.
Petitioner Balwan Bhama. Yes.
Yes, my lord. So, my lord, he is a director in the company by the name of, my lord, Messrs. Vaishno Devi Traders Private Limited, my lord. If my lords have page 23, this is the trading license, my lord, issued by the District Council. And at number 3, your lordships will see two directors, Balwan Singh Bhama and Sachin Kumar. Now, my lord, at page 28 is a registration with the ROC. Page 28, Annexure 2. And your lordships will see the name of the company is Vaishno Devi Traders Private Limited.
Yes.
On the next page, my lord, your lordships will find at page 29 the name of the directors. At the end, my lord, two directors, Sachin Kumar and Balwan Bhama, director, my lord. Now, my lord, at page 30, I'll just give a background, my lord. There was this matter, my lord, regarding illegal coal mining, my lord. Illegal coal mining. So there was a judgment by the Supreme Court, and under the directions of the NGT previously, certain coal were seized by the state government. Now those coal, my lord, which were seized were directed to be handed over to Coal India. Now thereafter, Coal India was to auction the coal, my lord. So, my lord, at page 30, your lordships will find the e-auction. E-auction, my lord. Right at the top, my lord, the date is 6th of March 2023, my lord. So, my lord, the seller's name is Directorate of Minerals Resources, Meghalaya. Location, Risa Colony, my lord. And your lordships will find at page 32.
Yes.
At page 32, my lord, this is an email issued by the company who is conducting the e-auction, and it says, my lord, this is dated 15th of March 2023. It says the provisional allotment of quantity of following lots of e-auction, so and so, my lord, dated 14th of March 2023, have been approved by the seller, Director of Minerals Resources. So these are the numbers, my lord, of allotment. And the allotment was, my lord, for 12,500 metric tons. At page 34, your lordships will see acknowledgement of payment, my lord, of the auction amount, my lord. Please find attached herewith payment confirmation letter of Vaishno Devi Traders Private Limited for quantity allotted in lot number so and so. The lot number, my lord, I had indicated in the previous email of e-auction so and so, dated 14th of March 2023. Some acknowledgement of payment is at page 34, and for some lots it is at page 36.
This quantities were what? These are lot numbers are there.
Yes, my lord.
What are the quantities?
Quantities I'll just indicate to your lordship. I'll just indicate.
So you were allotted 2 lots.
No, my lord. If your lordships come back to page 32,
Yes.
1, 2, 3, 4, 5, 6, 7,
The
8 lots.
payment is with regard to?
Payment at 34 is with respect to, my lord, lot number EJH01, my lord,
Means to in respect of 2.
and 05, my lord.
In respect of 2.
Yes, my lord. At page 36,
Yes.
it's with respect to other lots, my lord.
So
Again 38, my lord, another lot. Page 40, again another lot, my lord. Now, my lord, at page 41 onwards, my lord, page 41 onwards is the payment of royalty, my lord. Payment of royalty. This is Directorate of Mineral Resources, my lord. At the bottom, my lord, of the table, your lordships will see 1,000 metric tons.
where
At page 41, my lord, this is the tax invoice. Royalty at 5%. quantity is 1,000 metric
Page
tons.
41,
Page 41, my lord.
at the bottom.
At the bottom, my lord. At the bottom, in the middle, my lord, where it says quantity. An extra 5, my lord.
Yes.
So, my lord, I have paid the royalty, my lord. I've firstly paid the auction amount and now the royalty, my lord. Now, this is 1,000 my lord, metric tons, and the subsequent page, my lord, at page 43
Yes.
is another 1,000 metric tons, my lord. That makes it 2,000. Then at page 45, my lord, another 1,000 makes it 3,000, my lord, metric tons.
Yes.
And also the GST, my lord, I have paid. Now at page 49, another 1,000, my lord.
Page 46 also another, isn't it? 45, 46.
46, yes, my lord. 46 is the, yes, my lord, 1,000.
Anyway, what is the dispute about here?
My lord, this being the coal which has been purchased by way of auction, now my coal has been seized, my lord, as illegal. And proceedings under section 21 of the MMDR Act has been initiated, my lord. Now, my lord, that is being done in view of, my lord, a proceeding which is pending before the Honorable Division Bench, my lord. Your lordships will find at page 79. Now, I am Vaishno Devi, my lord, Traders, Private Limited. If your lordships have this at page 79,
Yes.
but before that, my lord, I'll just point out a certain order, my lord, issued by the Deputy Commissioner, because the Deputy Commissioner is the complainant.
This is a 482 application, isn't it?
Yes, ma'am.
You are seeking quashing.
Caution, my lord.
Now, do you expect this court to evaluate this evidence for giving you a clean sheet?
No, my lord. No, my lord.
We cannot do it.
Prima facie, my lord, this is my lord, legal coal, and why I'm
Now, what is legal coal and what is not legal coal? Can this court give finding under 482? See, what is law? The law says that at the stage of quashing, it is only the prosecution documents which is to be looked into, not the defense documents. So we cannot even go into your documents.
my lord, all these documents are before the court below, my lord.
That is all right. But
Yes, my
has the matter been charge sheeted?
Not yet charge sheeted, my lord, but there's a provision, my lord. Kindly have the act.
What about the stages? This is investigation stage also.
My lord, kindly
See,
have the act.
tell us. See, we can understand. You may have a very good case on
My lord,
merits,
my lord.
but then there is a restriction so far as our jurisdiction is concerned.
Correct, my lord.
We cannot give a
But
finding
I'm
on
compelled,
merits.
my lord, I'm compelled because, my lord, kindly have the act. I've also annexed the act, my lord, at page 161. This is the Mines and Minerals Development and Regulation Act, 1957. Now, my lord, the penal provisions, my lord, is at section 4.
Yes.
Section 4, my lord.
Yes.
What is relevant is, my lord, section 4.1 and section 4.1a. Now, my lord, I have been booked under section 21, 1, my lord. Penalties, my lord. Page 193.
Yes.
It reads, my lord, whoever contravenes the provisions of subsection 1 or subsection 1a of section 4 shall be punishable with imprisonment for a term which may extend to 5 years and with fine which may extend to 5 lakhs per hectare of area. Now, my lord, why I am compelled is, my lord, kindly have subsection 4.
Yes.
Subsection 4a, my lord.
Yes.
Any mineral, tool, equipment, vehicle, or any other thing seized under subsection 4 shall be liable to be confiscated. So, under subsection 4.1a, the court can confiscate by an order of the court competent to take cognizance of the offence under subsection 1 and shall be disposed of in accordance with the directions of such court. So, my lord, once my coal is seized and an application is made before the special court for confiscation if the confiscation is allowed, my lord, the coal will be disposed of.
Yes. If the
And this is all legally purchased coal, my lord. I have the.
That is what is to be determined. We cannot give a determination there. That is kindly understand that is. Court is trying to point it out.
No, my lord, I'll just indicate.
If there is a law which says that court competent to take jurisdiction will decide, then that will go there.
Lord, I'll just indicate, my lord. Kindly have page 90, my lord.
19.
90, my lord. 90. This is the complaint, my lord. This is the complaint. And what is the complaint, my lord? I'll just read. This is dated 28th of June 2023.
Yes.
This is issued by the Deputy Commissioner, my lord, to the SP of South Garo Hills. In reference to the above and in pursuance to your inquiry report referred above, wherein it is found that the ownership of Messrs. Jayama Coal and Messrs. Vaishno Devi is same. I don't know where they get this from, my lord, because it's a private limited company.
See, we cannot go and examine the correctness at this.
Correct, my lord. Now, just allow me to read, my lord. I am to direct you to continue with the temporary ban on transportation of coal of Vaishno Devi Traders Private Limited as per our letter so-and-so. Shri so-and-so, Executive Magistrate is hereby detailed to conduct raids and seize all the dumped coal belonging to Vaishno Devi Traders, in bracket, my lord, Messrs. Jayama Coal Private Limited, another company, my lord, in the district immediately and take appropriate action as per section 21 of the Mines and Minerals Act. This is also in reference to the order passed by the Honorable High Court dated 26/6/2023 in view of the PIL number so and so by Shri so and so. So this is not on account of the coal being illegal, my lord, on the ground that certain orders have been passed by the Honorable Division Bench, my lord, in the matter.
That you are transacting business in a different name.
My lord, I am an auction purchaser.
You see, these are allegations. These are yet to be proved. You see, whether this allegation is correct or not, we cannot give a finding. At least fact remains that there is something, some allegation is there, and that is good enough for.
Well, there's no finding by the Honorable Division Bench also, my lord. PIL has been fined, my lord. Allegations have been made. There's no order, my lord. Now this order, which dated 26.
Mr. Nangri, will issue notice.
My lord, only one prayer, my lord. I have a miscase, my lord. Though I have sought for, my lord, stay of the proceedings. However, I will press on two prayers, my lord. Prayer number 2, my lord, and prayer number 3.
But what is
my lord, the second prayer is to direct the special court not to confiscate the coal. It's seized, but not to confiscate and dispose it off, my lord.
That amounts to interim or passing interim. That we are not doing.
My lord, prayer number 2, my lord.
See, if the court confiscate anything, they will give you notice. You place your case there.
Lord, the problem.
The order passed for confiscation, is it not assailable?
Lord, it is assailable, but once it's confiscated, my lord, then it is sent for auction again, my lord. I have paid my royalty, my lord. I have paid my auction money, my lord. I have spent a lot of money, my lord.
That is to be seen whether
I have all my challans in place.
You see, you will have a remedy. Even injustice done to you, you will have remedy. It is not that, you see, you cannot just come and seek protection on this stage. My
lord may then issue notice, but my lord, if an observation can be made that no coercive steps should be taken against me, at least in person. At least in person, my lord. Everything is legal.
You are trying to obtain some order directly.
My lord, during pendency, my lord. I'm only asking for during pendency.
If you can make out a prima facie case, definitely. But then,
my lord, everything is legal, my lord. Nothing is illegal.
That is the problem. You see, why you are not. See, your entire petition is with regard to that.
Yes, ma'am.
You say that whatever you have procured, that is a legal procurement.
Yes, ma'am.
You see, now how do we decide it here? How do we go into those? How do we evaluate those documents?
My lord, all these things, my lord, I have already placed it before the Deputy Commissioner also, my lord.
Law is against you. Why don't you understand?
My lord, the law is not against me. It is legal auction, my lord.
How can we appreciate this? See, documents. You are questioning the merits.
My lord, there's a certification from the.
Can we look at your document and pass some order in your favor at this stage?
My lord, because the
Your
authorities are
entire
not looking into
argument
it.
is basing on the evidence which you have attached in your petition. Can you take cognizance of that and say that the allegation made in the FIR is not correct in that view, in view of what you say? Can we do that at this stage?
My lord, kindly have the seizure also. Seizure says it is my call.
You are
Can we
again
have the
coming,
seizure?
again coming to same thing.
Yes, my lord.
It is your call, but then whether it is legally procured or not legally procured, that is the main thing. Seizure will prove that it was seized from you.
It is seized from
It
me,
will
my
not
lord.
say that you are owning it legally.
Then, my lord, my kindly issue notice, my lord. Let them come with the reply.
You know very well the limitation. of the
I do understand, my lord. I do understand.
courts. Anything?
No, no, no.
Will issue notice if he is obtained instruction.
Absolutely.
And if he is whole, whatever has been seized, if it is legal, why to harass him?
Absolutely.
He has obtained it, procured it from your option. You invited him and now you again taking the
Lordship is,
The problem is that, this court cannot go into
well, Lordship is aware that matter is pending in full bench also. There's so many things happening, Kagati reports.
and it hard, Mr. P.
Let's see what reply comes.
For the petitioner, issue notice, returnable in 3 weeks. Mr. K. Khan along with so and so appears for all the respondents. That will do. This is matter after 3 weeks. In the meanwhile, respondent should obtain necessary instruction.
Lordship.
And the miscase you just say, will
Some
not shut you
protection,
down.
my lord.
We'll
No
just say-
coercive action. That's it, my lord.
No, we'll not.
My lord. Just on the person, my lord. I'm not on the mineral.
No, just the miscase also list along with the main case.
2 weeks, my lord.
No, it will come there. Let them have instruction.
Let them have instruction.
If they say that they will release you, then
Nothing
matter will
remains.
become infracted.
Then nothing remains.
My lord, because the matter is pending before the special court.
State is expected to be fair, isn't it?
My lord, they are
Let
expected.
us
my lord.
see. Let us see how much fairness.
I do understand they were under pressure
I
in
don't
the
think
PIL.
Mr.
my lord.
Khan will unnecessarily come and oppose.
Absolutely.
Mr. Khan is always very fair, my lord.
Mr. Khan will not become a mouthpiece of police
Absolutely.
until and unless there is.
Yes, my lord.
That he will do. We'll do it.
Whatever the document, the record speaks, we will bring it to the record.
We have experienced it, so we know it.
Deeply obliged.
Daily cost list, item number 1. Item number 2.
Yes. Yes.
Lordship, on the last occasion, the private respondent had they had sought time for filing their objection, Lordship.
Have they filed it?
Not
not
yet.
yet
They have
filed.
You have. Yes, Mr. Paske, you have not filed any
Your
objection.
Lordship, I'll seek 2 weeks' time, Your Lordship.
Lordship, I have one small prayer, Lordship, one small submission. Lordship,
How small it is?
Lordship, my prayer is this, Lordship. My interim prayer should be considered, Lordship.
Okay, once they are asking for time, interim, was there an interim order passed here?
There are some connected matters with this case on the last occasion. So in those connected cases, Lordship.
If there is no interim prayer here, how?
No interim prayer, Your Lordship.
Just show us, point it out when this interim order was passed.
But Lordship, I will pray that at least till the pending of this.
What is the matter about?
This is a civil suit, civil matter, Lordship. The thing is this, Lordship, that the dispute has arisen between two individuals regarding the
You are the
ownership.
private respondent.
The dispute is between the private respondent and me.
Yes, that is all.
But an FIR
Not with the private respondent, Your Lordship.
it's technical.
Not with
The private
respondent,
private respondent is representing someone
Just give us
who
the
claims
facts.
to be
Just
the
give
owner
us-
of the
give us
property.
facts. Why do you want an interim order?
The thing is this, Lordship, because of this FIR, Lordship, there are two connected matters arising out. Two connected matters, two connected FIRs are also there, and in those two connected FIRs, already the stay order has been given.
Madam, you sit down. Just.
So the thing is this, that
not correct, Your
since only my FIR, Lordship, the investigation is going on. So Lordship, I am suffering because the police, the investigating agencies are calling me off and on. They are just
That is your
harassing me.
FIR, isn't it?
No, the FIR filed by the private respondent.
So you said there are two FIR.
3 FIRs. These are different matters and pending before different courts.
Filed against you.
No. There is the confusion, Lordship.
Lordship, let the objection come from the private respondent, and we can hear the matter and then decide, Your Lordship.
One
At
thing
this
will
stage,
clear,
I don't
Lordship.
think,
I will
Your
just show Lordship one.
there is any ground for giving any interim relief.
Lordship,
Your Lordship, in this matter, what has happened?
there are 3 FIRs which are registered as
Hold
FIR.
on, Mr. Paske, we'll come to you.
Case number. These are numbered like this, Your Lordship. Tura PS case number 23 of 1, 2, 3 like this. So, Lordship, in Tura PS case number 23 of 4 of 2023, this Honorable Court was pleased to pass and stay order. So, Lordship, on parity, on similar ground, Lordship, I am also praying for a stay order, Lordship. And why, Lordship? Because since the other FIRs, Lordship, the investigation has been stayed. So now only I am being left out. So I am facing the brunt of the investigating agency. And Lordship, the thing is this, Lordship, that this is a completely civil matter, which is the part and parcel of this adjudication.
Madam, this order, have you... This order, is it connected to the same matter?
Your Lordship, actually what has happened, this is, there is a little lot of fraud going on in this GHEDC with regard to the mutation of the property in different names. Now this petitioner here, Your Lordship, they are also involved in this fraud, Your Lordship, which is why the private respondent has filed an FIR against them, Your Lordship. So my prayer is that, Your Lordship, at the moment, Your Lordship, there's no ground for giving any interim relief.
No,
it is not a civil dispute per se, Your
The query
Lordship.
placed by the court is that, is it connected with that matter, which in connection with this order dated 9/8/2023 was passed?
The FIR is also different, Your Lordship.
It's different thing.
Not the same
It is not arising out of the same case.
But the issue is same, Your Lordship.
There is an
See,
element
there
of fraud in this whole
At the
thing.
initial stage, you should have placed it. That you have not.
Lordship, I have raised it. Lordship had said that wait for 1 month.
Where is the petition? This one? No.
Anyway, we'll just wait for the thing to
Lordship.
objection to be filed, and then we'll decide it finally.
Lordship. Very well.
Mr. P.R. Paske, Counsel Neptune for the respondent number 2. Please for granted. Further, how much time you want?
2 weeks, Your Lordship.
2 weeks time for filing the objection in the matter. We are allowed to list after 2 weeks. Please file it, Mr. Do not delay.
I'll do so. Actually,
Oblige, oblige.
And deeply obliged, Lordship.
obliged, your lordship.
Item number 3.
Decide meanwhile what is to be done. Yes, we have given you 2 weeks time for seeking instruction, and thereafter you decide.
Obliged.
Yes.
May it please your lordship.
Yes.
That matter yesterday. Just praying for a direction, your lordship.
Yes, where the supply of copies.
Supply of copies. In view of the order, the Annexure 10, page
See
335.
the order dated 17/8/2023, passed by the Court of Chief Judicial Magistrate. This copy was supplied by you.
Yeah, yes.
Mr. Mohanto,
Yes.
if that be the thing, then matter ends there.
Yes.
Have you seen the copy of the order? Kindly, you have a
Yes.
copy. Please give it to him. See, have a look.
This one you have. Where is it? Made available to the counsel for the petitioner accused on so-and-so. So-and-so possible, right? Right. Oh, see? You didn't get this.
Any reason to disbelieve this court's order?
No, your lordship, what had happened, all the documents has not been supplied. That is the reason.
What is annexure 3 there? Referred to in that order.
See, where was this annexure?
Do you want to say that this order was passed behind your back?
Record placed before me on call. Senior producer. Yes, we are not heard about this.
This order has been passed on 17th August.
17 August 23, record placed before me today on call.
So then now it will be incumbent upon you to verify this.
We have to verify that. Oh, we can, your lordship may just pray, since this order has come, so I think it can be disposed of with a direction that will verify this. Yeah.
Because see this,
and whatever document,
the middle part of the para 2 of the thing, what this court has.
That pursuant to the order that is also passed with all the petitioner accused person has checked and sorted out the relevant documents and papers, and as desired by him, copies of the same have been supplied to him accordingly.
That is specific. That is specific. So until and unless you dispute this order, we will dispose this matter on the basis of this order.
No, input order is.
Or you can do one thing, mister. You can take instruction, let the matter come up next week. If you have any confusion.
No, your lordship, that input order, what we have input, 26/6/2023, this is of August. That is of June, the input order.
But then that's too.
This is subsequent.
That is subsequent. That is why no cause of action.
But
now see, it may be after that. You have challenged the order passed in June.
June.
You are here. Yes. But then this order dated 78 records, 17/8 records that you were supplied with the copies. So there is a specific, somebody must have represented you there. Somebody must have represented you there. Are you whether the same set of counsels are?
Same. Yes. He was Mr. Singh was.
Then please verify this. If you have any doubt, please verify this. Come back to us. Or if you want, that can be disposed of on the basis of this indisposed.
Any document is left.
No, only then it can be done, since it has been there, what my colleagues say. So if any document left, as per discuss, it has to be verified, your lordship.
That is what the annexure 3 becomes important now.
So
the annexure 3, which has been referred to in that order, that becomes a part of record there, isn't it?
It will be part of
bind both the parties, isn't it? So that is what we need. If you are disputing it.
No, only one thing, if lordship can just dispose of this, whatever document did not supply, that again no, that would be.
That means you have to have some grievance remaining. So that is, you say it specifically.
No, what my colleague says is that he was there very much, but this order he has not seen it. So because prior to that,
what is more important is, Mr. Mohanto, is this annexure 3. Annexure 3 will give you an idea about what are the documents.
Yes.
Now, if you find that some of the documents from there or any of the documents from there is missing, then you can do it.
We'll verify, your lordship. So instead of pending it, so if the order comes like this, your lordship can be disposed of. If any document missed in the annexure 3, as per that, and what supplied your lordship, then we can just ask the court to supply that. I think that can suffice. Instead of delaying the proceeding. If any document is left out, then if they supply that, we'll find out that one, because we have to verify this. As per
But
that.
then in such a case, you will approach that court. Why to come here?
We'll approach that. That can be disposed of.
Yes.
Only with that right.
Hard. So and so and so and so. Will participate. During the course of hearing, Mr. K. Khan, learned AG, placed on record an order dated 17/8/2023, passed by the learned Chief Judicial Magistrate Iskasiel Shillong in GR 130 within bracket as of 2015. Which reveals that the grievance raised by the petitioner in this instant application, in this instant writ petition before the court, has been redressed. The order of the trial court specifically recorded that the petitioner stroke accused person has specifically recorded that in pursuant of the earlier order dated 10/8/2022 passed by this court, the petitioner stroke accused person has checked and sorted out the relevant documents and papers as desired by him. Oh, and as desired by him, not as and as him, copies of the same have been supplied to him accordingly. Paragraph. In view of the specific order passed by the learned trial court, by the learned Court of Chief Judicial Magistrate, there remains no more grievance to be redressed by this court in this present criminal writ petition. Stop. Accordingly, the same is disposed of, being infructuous. Stop. However, it will remain open for the petitioner to see Annexure 3. Without knowing Annexure 3, will it be?
No, I understand. You just
to point out before the trial court, in the event if it is found that any of the documents enlisted in Annexure 3, which was placed before the trial court, was just say was not supplied to him. Just say the last line. However, it would for the petitioner enlisted to him.
That will do, I think.
That will do. How about your lordship? Only here, just I have noticed.
Just a minute. In the event it is found that there is non-supply of any of the documents as mentioned, any of the documents mentioned in Annexure 3, it would be open for the London Trial Court to pass appropriate order and directing for supply of the same to the petitioner. It's all right. You are following the order or not?
Lordship, I'm following.
Thought that you were somewhere else.
No, Lordship, I was following. I was focusing on the Annexure 3.
Then maybe little bit correction here there.
No, perfectly.
Only wanting your lordship.
If they're entitled to,
lordship
you
here,
don't receive a document, they're entitled to, they should
what
be entitled.
the previous IO, I think he demised. So again, further investigation has been given to this.
No, but then what we have to do with this?
No, we had nothing to do. Just
Right now we are confronted with Annexure 3.
only confirm.
That is the issue. You have any other issue outside this, you can again come back.
We will that.
But then tell one thing, Mr. Mohanto. Why by criminal rate?
I know that's
Why you have come by way of criminal rate petition? Though it was an earlier round of litigation,
yes.
the court has entertained, and right now also this court has. But then this is a question
I know. I'm
which
I'm
came. The criminal rate petition, is it that for every say like failure in the procedural aspect?
I know. I'll walk on that.
Please, it's a that thing. Because see nowadays, there remains hardly any difference between 482 application and criminal.
Yes.
Correct.
There, but then the law says there is some difference.
Yes.
So that is what. We should not, open some.
True.
Like arena which otherwise is normally
Not required to be. Not required. I understand.
The things we say extraordinary jurisdictions. Really cannot be a most ordinary jurisdiction.
Yes.
I know. I'll look into it.
Lordship is correct.
Deeply obliged by accommodating. Much.
Item number 3.
Yes, Mr. Sinkan, what is this? Oh, that supplementary judge.
My lord.
What are the orders which are under challenge? How many orders are under challenge?
Two orders, ma'am. One is order dated 29/6/2022.
What is the first order?
29/6/2022 and 6/12/2023.
You have finished your part of submission.
My lord.
You have finished your argument, isn't it?
My lord, already.
Your is over. Anyway, just take us to these impugned orders.
Page 25, your lordship. The
Page
first,
25.
The order dated 29/6/22, that is at page 25.
Yes. There are two orders reflected
Final
on page
document.
25.
Then lordship, the second order, that is
No, but then which order is under challenge? There are two orders on page 25.
Both the orders.
both the order, your lordship. Both the order.
25/5/2022 and 29/6/2022, isn't it?
My lord.
Just let us go to these orders.
29/6/2022 order says, my lord, seen forwarding of the original FSL report submitted by the IO in connection with this case. Accused Sri Niyat Singh Vania is present along with SDC Sri so-and-so. The case is fixed for filing of final argument by the prosecutions. Learned PP, however, states that since the FSL report has been submitted to the court, she may be allowed to file her additional list of witnesses in this case. Learned PP to file appropriate application since the case is now fixed for final argument.
Yes. Next order which is under challenge.
Yes.
Now you say supplementary charge sheet. Where is supplementary charge sheet?
Now, my contention was that, my lord, if any evidence, new oral or documentary, after filing of the charge sheet, if it is found that there is new evidence, either oral or documentary, if that is to be produced before the court, then it can be done as in terms of the law only under section 173 clause 8.
So it means there is no case of supplementary charge sheet.
My contention is that, my lord,
What will constitute a supplementary charge sheet? See, there are two aspects.
My lord.
You just enlighten us on that.
Right.
Mere filing of a document at a belated stage whether it would be constituted as filing of supplementary charge sheet or not.
Yes.
Because here this will be supplementary charge sheet. That is what you want to say.
My lord. Now, as far as
So, as per you, that this order dated 29/6/2020 allowing this FSL report to be taken on record.
this is wrong in my
No,
understanding.
no, that amounts to
Violation of
no, that amounts to taking into record the supplementary charge sheet.
because
we have to be clear. You see, because
Right.
whatever you say, that will be reflected in the order.
yes,
It should not be something like that. You say later on that was not my submission.
Right.
It was recorded. So we have to be very much careful. Are you terming it as equivalent to filing of supplementary charge sheet?
right, my lord. Why I am saying so, my lord? As far as CRPC is concerned, there is a provision when you get new additional evidence, how this to be produced before the court. That is only under section 173 clause 8. There is no other provision in the CRPC, my lord, under which a new evidence, oral or documentary, can be produced before the court. That is only under section 173 clause 8. That is my submission, my lord. That has to be through a supplement by a supplementary charge sheet, my lord.
By a supplementary charge sheet.
Yes.
Now that
through
is what. Then is it not that you are contradicting your own submission? You say that the very taking of the FSL report amounts to supplementary filing of a supplementary charge sheet.
My lord, my contention is that if the prosecutions has to adduce a new evidence, that has to be done only by following the provision under 173 clause 8. There is no other provisions, my lord.
Okay.
Finish?
Yes.
What is the other order?
The other
Next page,
Lordship will find at page 26.
26.
That I'll refer your Lordship.
Just a minute. Just hold on.
Lordship.
So, Mr. Shulai,
Lordship.
the sum and substance of Mr. Singhan's argument is that the only possible way of bringing in into
FSL
fresh
report
evidence-
is by a
fresh
supplementary
evidence-
charge sheet.
fresh evidence in a criminal case by way of supplementary charge sheet, and there is no other.
Yes.
So that has not been done here, so this cannot be taken.
My humble and respectful submission, your Lordship.
Correct, Mr. Singhan? That is your content.
Right, my lord.
My humble and respectful submission, your Lordship. It is not a supplementary charge sheet, your Lordship. In fact, it is only a filing of the report of the FSL, your Lordship.
Was there any permission sought by the
Lordship, that I'm coming to the order. Lordship will kindly come to page 29. And then what is supplementary charge sheet, your Lordship? I'll place a decision, your Lordship, on that.
Yes, that will be important. Page 29.
Page 29, Lordship.
Yes.
From the hearing.
Yes.
From the hearing of both sides today on the application under section 3.
In this page 20.
Page 29, Lordship.
Acha, you are just reading part of it.
Lordship. 1, 2, 3. Three paragraph from
Yes,
the
yes.
bottom.
Yes.
From the hearing of both sides. Lordship is with me.
Yes, yes.
On the application under section 311 CRPC, firstly on the disputed forwarding of the DNA FSL report without filing the supplementary charge sheet in proper format, but by mere forwarding letter which was received by the court on so and so. But since the same has not been returned back to the IO, which amount to the acceptance by the then judge, who is my predecessor, which is of the same share, hence this court will not comment on it, since the criminal case has the same court cannot review. Secondly, on the disputed delay of filing of the supplementary charge sheet of submission of DNA FSL report after 8 years, since this court during the executive time by the order dated has allowed, Lordship kindly. So that submission of the
So there was an permission given.
Lordship, yes.
On record.
So
By the order
this will
dated-
be then covered by that Supreme Court decision that rise that CBI made 2002. There is some case probably on that.
Lordship, I have not come across that, but other
So
judgment I
that
have
part
brought.
is not disputed that there is an order dated
Yes.
1/11/2013.
Yes, your Lord. See, Lordship, since this court during the executive time by order dated 1/11/2000 has allowed the prayer of the IO for its submission, and since this court during the then judge by did not return the original FSL report submitted by a mere forwarding letter, hence this court will not commence on since the same court cannot review. Then Lordship kindly come to page 30. First paragraph from the bottom. For the above requisite under section 311 CRPC,
This just a minute. This order is about 311.
311, Your Lordship, yes. Because what happened, the prosecution filed an application under 311, Lordship.
This order dated 29/6/2022 was not challenged then there.
No, no, Your Lordship. No, Your Lordship. Lordship, you will find that application, the 311 application of the prosecution at page 32, Your Lordship. At page 32.
Page 30?
32, Your Lordship.
Yes.
Page 32. So this is the application, Your Lordship. This is the application. Yes. Then, Lordship, I kindly come back to that to page 28 or page 30, Your Lordship. That order.
Yes.
For the above requisite of section 311 CRPC, this court has gone through the material on record is seen to be a case where a victim of 13 years allegedly raped by the accused person with threat to kill if the incident is disclosed in one. The charge has been framed against the accused person under section 376, 506 IPC, and 8 PW had been recorded with the statement of the accused under section 313 recorded. It is also seen as per the charge sheet dated so the same has been submitted under section so with a prayer to submit, Lordship. The supplementary charge sheet when DNA FSL report will be received, which was allowed by the order dated 1/11/2013. It was already allowed, Your Lordship.
So, so far as this part is not disputed.
Yes, Your Lordship. So where is the question of supplementary? Then now I'm coming, Your Lordship. What is the supplementary charge sheet?
Yes.
Lordship, kindly. This is a very old judgment, Your Lordship. It is from the Patna High Court, Your Lordship. Yes. Lordship will kindly come to paragraph 9 of that judgment.
Yes.
From a simple perusal, Lordship, before that, Lordship, para 8, that is the order, the section 173, 73(8), Your Lordship, quoted by the Honorable Patna High Court, Your Lordship. Then the finding. From a simple perusal of the above provision of law, it is crystal clear that a supplementary charge sheet can legally be submitted provided further investigation in respect of all offence after the first charge sheet is submitted is held, and upon such further investigation, further evidence is obtained. Thus, a supplementary charge sheet can be submitted in respect of additional evidence collected in course of further investigation held, which could not be available in course of the investigation held earlier. So, what is the question, Your Lordship, of filing a supplementary charge sheet, Your Lordship? Because that FSL, Your Lordship, is part and parcel of the.
It cannot be, because this FSL report is not an outcome of the fresh investigation.
Absolutely correct.
So it cannot be regarded.
Lordship, absolutely correct. Lordship.
And once court has given permission,
yes. Then, Lordship, Lordship, whether there at the time of the filing of the charge sheet, Your Lordship, if no documents, Your Lordship, that is not. That is Lordship, kindly. This is 2024, Your Lordship. 2024. Lordship will kindly come to paragraph 24. Paragraph 24, Your Lordship. Lordship, kindly come down below, that is 22. Paragraph 24, Your Lordship. Then kindly come to
just a minute.
22, Your Lordship.
Paragraph 24 will be in page.
Lordship, it's not paging, Your Lordship. This is SCC online.
Yes, 24 is in Dinesh Dalmia.
Lordship,
yes.
Lordship, can you come to 22? It is true.
30?
22, Your Lordship.
Yes.
It is true. Lordship is with me?
Yes.
It is true that ordinarily all documents accompanying the charge sheet, but in this case, some documents could not be filed with which were not in the possession of the CBI. So it's same case here, Your Lordship. And the same way with the so-and-so. As indicated here and above, the said document were said to have been filed on so-and-so, whereas the appellant was arrested. The appellant does not contend that he has been prejudiced by not filing of such document with the charge sheet. No such plea no such plea in fact had been taken. Even if all the documents had not been filed by reason thereof, submission of charge sheet itself does not become vitiated in law. The charge sheet has been acted upon as an order of cognizance has been passed on the basis thereof. The appellant has not questioned the said order, taking cognizance of the offence. Validity of the said is not in question.
See, there will be more specific decision by the apex court in the same.
Lordship, I have not
Anyway.
come across your Lordship.
Probably this will be 2000, I think 2000, 2001, something.
This Lordship, this another judgment, your Lordship, is from the Honorable Delhi High Court, your Lordship.
It's okay. It's on which point?
On that documents, your Lordship. On documents, your Lordship.
All these judgments will be needed.
Lordship.
All these judgments will be needed to be referred if it is on the same thing. Anyway, yes.
Lordship, kindly refer to paragraph 12.
Yes.
May I read it, your Lordship?
Yes.
It may further be noticed that right of the investigating officer for further investigation, here the Lordship is not further in terms of section is not taken away only because the charge sheet is filed under subsection so against the accused. Ordinarily, though all documents relied by the prosecution should accompany the charge sheet, nonetheless, if for some plausible reason all the documents are not filed along with the charge sheet, that this itself would not invalidate or vitiate the charge sheet. If upon the material, Lordship, yes. This is
okay, but then it's okay. This is not a case of invalidating or vitiating charge sheet. That is not his case. So that may not be very.
So, Lordship, that
the contention of Mr. Sinkan is very simple. He wants to say that any late entry of evidence
is not, Lordship.
Amount to
from my understanding, your Lordship, of that.
Right. Probably, if this court is correct, there will be one decision in 2002 holding this.
Lordship, then Lordship will have to allow me some time. Then I'll do some research on that.
We'll conclude it. I think.
Lordship. Then so, Lordship, that Patna High Court judgment, your Lordship, that is exactly on the point.
Very fair, and if Mr. Sinkan doesn't get that opportunity to see what this is decision. Probably, Mr. Sinkan, this is if this court has not mistaken, that is a case of 2002, reported in 2002. This is CBI versus some Rai or Pai.
We'll have a look at it, my lord. And as far as this order dated, my lord, 1/11/2023, which my learned senior is referring, my lord, even in my understanding, my lord, I may be wrong. This order is pertaining to the charge sheet.
See, if you say, do not say you are wrong.
Yes.
No,
my lord.
Here for making it
right. No, my lord, why I'm saying the order is not with me right now, but this order pertains to at the time when the charge sheet was filed and charge sheet was taken on record. Because in the charge sheet, my lord, there was a prayer when they have just mentioned there that they will file the supplementary charge sheet as soon as they receive the DNA. Only that much. It was not allowed. It was in the, this prayer was there in the charge sheet, my lord. And there was no specific order in my understanding, my lord, granting that to allow the supplementary charge sheet at the later stage, my lord.
See, that is what you see, you verify it. If it is
Yes.
incorrect thing,
My lord.
then definitely this court will interfere.
My lord.
See, understand, Mr. Shulai has specifically pointed out that there exists an order dated 1/11/2013.
Right.
Okay.
Allowing the
late submission of the.
I'll try to get a copy of.
Now that becomes crux of the issue. Now
Right.
you deny, if you say there is no such order. You
No
place it
order,
before us.
there may be order, but that was relating to
But
the
if you say
submission of the
maybe
charge
that
sheet.
order will be of very, see, it will be
Crucial,
of much relevance. So,
Right.
so far as deciding this issue.
Try to get the copy.
Two things what we should keep in mind, that one submission is that late entry of any evidence
Right.
will amount to filing of supplementary charge sheet.
Right.
And that can only be done after complying
73.
73 Supplos 8. Here it is not case where these stipulations were not complied with, could not have been taken to record.
Right, my lord.
And Mr. Shulai's case is totally different. He says no, that there is no question. The question of, you see, like supplementary charge sheet will not come here.
Right.
It's a mere furnishing of some evidence at a later stage, which is permissible in law and most importantly in view of court allowing it.
Permissible
Now,
in law.
there probably what Mr. Shulai's submission has made me recollect of some decision. You see, like that this court had come across a time, probably in 2000, 2001, 2 and all. That is Central Bureau of Investigation versus some.
Lordship, in that Delhi High Court, that it has been referred that, but it's 24, Your Lordship. This is Central Bureau of Investigation versus Kapil Wadha 1.
No.
Then Lordship, I'll...
Right, fine. Anyway, we'll get it. We'll get it. Then we'll do one thing.
Lordship.
This will not be proper to take cognizance of that thing. Lapses. See, Mr. Sinkan. So we'll do a thing. We'll place it next week.
My lord.
When shall we place it?
After a week, my lord.
Lordship, when
By
we...
2 days.
Just see.
2 days. 3rd, no?
On 13, Your Lordship?
13, my lord.
On 13.
Will not be too this thing. It's okay. 13th. Anyway.
Or Lordship, we can have also on 8. On 8 also will do. On 8.
That will be better because this court tends to forget.
My lord.
So on 8, Your Lordship.
My lord, I need to get the copy of the order also. So let it be on 13, my lord.
Okay.
Lordship.
On the joint request of the parties, this is matter on 13th.
Oblige.
I'll give you the citation. Just. We'll retain those copies of citations.